In part 3 of our 5-part webinar, CMP and NTSO Complaints, Dominic Markward with the Office of Compliance and Enforcement reviews how to file an answer and the consequences for not filing an answer for those who've received a civil money penalty or no tobacco sale order complaint. Coming up now in this edition of FDA's Tobacco Compliance Webinars.
Thank you for watching Part 3 of our webinar on CMP and NTSO complaints. I'm Dominic Markward with CTP's Office of Compliance and Enforcement. The FDA has created a series of 5 webinars to assist you, retailers and small businesses who have received an administrative complaint seeking a CMP, also referred to as a civil money penalty, or an NTSO, also referred to as a no tobacco sale order. This webinar is the 3rd webinar in the series. In this webinar, we will focus on how to file an answer and the consequences for not filing an answer. The 5 webinars in this series will cover Part 1, Introduction to CMP and NTSO Complaints, including a list of common terms compiled into a glossary and general information on what retailers can do after receiving a complaint. Part 2, How to pay a CMP using the online payment portal. Part 4, the settlement process, and Part 5, the hearing process, including what happens before the hearing is conducted, during the hearing, and after the hearing. All 5 webinars are available on the FDA Tobacco Compliance Webinars page. To access the webinars, visit www.fda.gov, type FDA Tobacco Compliance Webinars in the search bar. Follow the FDA Tobacco Compliance Webinars link in the search results to find all available webinars. The webinars are organized by year. You can watch all 5 webinars in order or skip ahead to a webinar topic of your choice. In this webinar, we will discuss what an answer is and what it should include, deadline for filing an answer, how to file your answer using the Departmental Appeals Board, or DAB, electronic filing system, the initial order establishing procedures, or IOEP, and the guidance establishing procedures, or GEP, requesting an extension of the deadline to file an answer, and consequences for failing to file an answer. Our first topic of discussion is, what is an answer? An answer is a formal response to the CMP or NTSO complaint. More specifically, it is a legal document that you will file with the DAB that either admits or denies the allegations in the complaint. When we say file, we mean officially submitting your response to the DAB using your case information. Your answer should include written responses admitting or denying the allegations in the current allegations section of the complaint. Please note, if you do not expressly deny an allegation in the complaint, it will be considered to be an admission. In your answer, you can disagree with some or all of the allegations in the complaint. You may also disagree with the penalty sought. You should include in your answer the reasons you believe the amount of the CMP or the duration of the NTSO should be less than what is sought. Your answer will be considered a request for a hearing unless you explicitly waive the right to a hearing. We will discuss hearings more in depth in the 5th webinar in our series titled The Hearing Process. You must file or submit your answer to the DAB within 30 calendar days after receiving the complaint or request an extension. Requests for extension will be discussed later in this presentation. Remember, filing means submitting your document to the DAB to your specific case file. Please note that the answer is considered filed when it is received by the DAB. Your answer must be submitted to the DAB. Administrative law judges, or ALJs, from the DAB Civil Remedies Division preside over CMP and NTSO cases. Their role in CMP and NTSO cases is discussed in detail in our first webinar. If you did not view the first webinar, you may want to view it to have a better understanding of the ALJ's role in this process. The DAB asks that you submit your answer using its electronic filing system. The system is called the DAB e-file. In order to use DAB e-file, you first have to go to the DAB e-file website and register for an account. Instructions on how to register and use DAB e-file can be found on the DAB e-file welcome page. You will need an email address, business address, and phone number. If you require further technical assistance, you can also email the DAB with your questions. You can contact the DAB at the email address provided on the slide. If you are not able to submit your answer electronically, you may request a waiver from, meaning ask permission of, the ALJ assigned to your case to allow you to submit your answer by mail instead of through the electronic system. But remember, you must file your answer within 30 calendar days of receiving the complaints. So if you need to request a waiver, you should do so as soon as practicable after you receive your complaint. You must submit your waiver request by mail, and your request must explain why you are unable to file your answer electronically. The address to send a written request for a waiver from e-filing will be provided to you in the cover letter that accompanies the complaint. The address is also contained in documents sent to you by the ALJ. We will discuss these documents in the next slide. The ALJ will notify you if your request for a waiver from e-filing is granted. Please note that regardless of your request, you are still responsible for meeting all deadlines set by the ALJ. Generally, after the FDA Center for Tobacco Products files a copy of the complaint with the DAB will assign an ALJ to the case, and that judge will send you and the FDA Center for Tobacco Products a document that may be called an Initial Order Establishing Procedures, the IOEP, or the Guidance Establishing Procedures, the GEP. Some ALJs issue the IOEP and others prefer the GEP. The IOEP and the GEP serve the same purpose. These documents notify you of the date by which you must file your answer. This date is very important. Later on in this webinar, we will discuss some potential negative consequences if you fail to meet this deadline. The IOEP or GEP will usually provide a form to help you submit your answer. You are not required to use this form. The form is provided for your convenience to give a sample format for your answer. If you are unable to submit your answer within 30 calendar days of receiving the complaint, you may request an extension. In your request for the extension, you must explain why you need the additional time to file your answer. The ALJ may grant an extension of up to 30 additional days, but only if good cause is shown. A request for an extension of time to file an answer must be filed within 30 days of receiving the complaint. Much like the process for submitting an answer, you must first register with the DAB to request access to DAB e-file to file your request for an extension electronically. Please follow the same procedures described earlier in this presentation for filing an answer to request access to DAB e-file or to request a waiver from the electronic filing requirement. A request for extension is not automatically granted. The ALJ will issue an order notifying both parties if the extension has been granted or denied. Unless the ALJ grants your request for an extension of time, you must submit your answer by the original due date. So again, if you need additional time, you should file your extension request as soon as practicable after you receive the complaint. Regardless of whether you submit your answer through DAB e-file or whether you receive a waiver and submit it by mail, it is important to file your answer by the deadline. The deadline is either within 30 calendar days of receiving the complaint or by the date determined by the ALJ if an extension is granted. If you receive an IOEP or a GEP, it will also include your deadline to request an extension or submit your answer. Failure to submit a timely answer may result in the ALJ issuing an initial default judgment. An initial default judgment is a written decision issued by the ALJ that can occur if you do not meet documented deadlines. It finds the allegations listed in the complaint to be true and imposes the full penalty requested in the complaint. In other words, if you fail to meet your obligation to file an answer within 30 calendar days, an initial default judgment will be issued against you, in which the ALJ will find you responsible for all of the violations alleged in the complaint and will impose the CMP or the NTSO as requested by FDA's Center for Tobacco Products. The default judgment is binding 30 days after it is issued by the ALJ unless it is timely appealed. You can avoid a default judgment by taking one of four actions. 1. Filing your answer by the due date, or 2. Successfully requesting an extension of time to file an answer and meeting any new deadlines that the ALJ establishes, or 3. Acknowledging and paying the full CMP amount or agree to an NTSO duration before the deadline for you to file an answer, or 4. Settling your case with the FDA's Center for Tobacco Products before the deadline for you to file an answer. The settlement process is discussed in more detail in our 4th webinar in this series. An initial default judgment becomes final and binding 30 days after it is issued unless you file a timely appeal to the DAB or a motion to reopen the case with the ALJ. When the ALJ issues a decision, you will be provided with information on appeals. Once a default judgment becomes final, you are responsible for paying the CMP amount specified in the final decision or complying with the NTSO. For a default judgment of an NTSO complaint, you will receive a letter from FDA Center for Tobacco Products with the dates of your NTSO period during which you are prohibited from selling tobacco products to anyone. This concludes our discussion of how to file an answer and consequences for not filing an answer. To summarize, we have discussed what an answer is and what an answer should contain, the due dates for filing an answer, the DAB filing requirements, including DAB e-file and how to request a waiver from electronic filing requirements, the initial order establishing procedures, or IOEP, and the Guidance Establishing Procedures, or GEP, how to request an extension of time to file your answer, and finally, consequences for failing to file an answer. Now that we've covered the basics of answering a CMP or NTSO complaint, we encourage you to view the other webinars in the series to help you better understand the CMP and NTSO processes. The previous webinars in this series were Part 1, Introduction to CMP and NTSO Complaints, and Part 2, How to Pay Your CMP Using the Online Payment Portal. The remaining webinars are Part 4, the Settlement Process, and Part 5, the Hearing Process. All 5 webinars are available on the FDA Tobacco Compliance Webinars page. To access the webinars, visit www.fda.gov and type FDA Tobacco Compliance Webinars in the search bar. Follow the FDA Tobacco Compliance Webinars link in the search results to find all available webinars. The webinars are organized by year. Thank you for watching Part 3 of our webinar on CMP and NTSO complaints, brought to you by the FDA's Center for Tobacco Products, whose mission is to protect our kids and the nation's health from the dangers of tobacco.